Welcome to another episode of Tutorials with Ike. We are going to be solving some questions on legal environment of business. And these questions are 2023 questions, yes, past questions. So just last year. So it's important to take them very serious so that you know how the questions are set, the structure and everything. And we're actually going to be given 30 multiple choice questions and 10 theory questions. You get it? And this paper is the same. It's actually the same structure. You get it? So it's important to take it serious. So let's start with the multiple choice questions. So for the multiple choice questions, there are 30 questions. So I'm going to read them one by one. So the first one says, Akushika, an employee of Healthy Eating Restaurant, is in a dispute with her superior, Mrs. Kwanzaa, who failed to honor her obligation under the contract of employment signed by them. The court has advised that they both seek to resolve their issues by means of mediation. What should they expect in this mediation? A. The mediator is expected to take sides in the matter and give his judgment on the issues. B. The mediator is expected to facilitate and be neutral without taking sides. C. The mediator is expected to give expert and biased views of the strengths and weaknesses of the case. Then D. The mediator is expected to identify the real interests and fears of one of the parties and get him to focus on those interests and fears. Alright, so straight away we can see the answer is B, because for a mediator you're supposed to be neutral. So most of the information they give here are almost irrelevant, or they are not really useful here. They're Akushikan employee, whatever, they are not really useful. What is actually important here is that it is mediation. So you have to know that anytime you are inviting a mediator, once it's mediation, the mediator has to be neutral. If it's arbitration, that's when the arbitrator takes sides. But for mediation, the mediator has to be neutral. So assuming the question said, what should they expect in this arbitration? The answer would have been, the arbitrator is expected to take sides in the matter and give his judgment. So just keep it in your mind. Anytime it is mediation, the mediator is neutral. He doesn't have a say. You are supposed to be neutral. Yes, so that's for the number one. Now let's move on to number two. So number two says, Adra Dokia has over the past few years had to deal with a squatter who is living on her land, and all attempts to evict her have not been successful. She has come to seek your advice as she has heard you just completed a legal environment of business course at UPSA. The land in question is worth 300,000 cedis. Advise her as to which court is best to seek redress. So A is the Supreme Court, B is the Court of Appeal, C is the District Court, and D is the Circuit Court. Alright, so for this one, the answer is the Circuit Court. So the thing is that the Circuit Court is the only court that deals with land issues. For the Supreme Court, they don't deal with land issues. They deal with constitutional matters and all that. For the Court of Appeal, it's an appellate court. Do you get it? So they, assuming maybe you send your case to the District Court and it's not successful, then you send it to the Court of Appeal. So you don't go straight there. You get it? Then the C is the District Court. The District Court doesn't deal with land cases. Do you get it? So the correct one is the Circuit Court. They deal with land cases or any other case up to 2 million cedis. You get up to 2 million cedis. So once it's more than 2 million cedis, you go to the High Court, not the Circuit Court. Now let's go to terrain. Terrain says, for an acceptance to be valid, it must be A, partial and qualified, B, partial and unqualified, C, absolute and unqualified, then D, absolute and qualified. For partial and qualified, when you say something is partial, it means you're not accepting the offer fully. You get it? Maybe I'm saying I'm selling you a 3-bedroom house. You're like, oh, you want only 2 bedrooms, so you want only just 1 bedroom. You get it? That's partial. So you're accepting some parts of the offer. And qualified means that you're asking for other terms. Maybe I'm selling you a house for 2 million cedis, but like you should pay fully or you should pay at once, but you're asking for maybe installments or any other things that are not in the original offer. So once it's qualified, it becomes a counter offer. Yeah, so straight away the answer is absolute and unqualified. So absolute means that you're accepting the offer how it is. Do you get it? If it's a house that I'm selling 3-bedroom, you're accepting it how it is. Then the unqualified means that you're not asking for new terms. You get it? You're not bringing in new terms. Whatever I say is final. Do you get it? So for an acceptance to be valid, it must be absolute and unqualified. So the correct answer is C. So now let's go to number 4. So number 4 says, by their powers and functions, the courts in Ghana can generally categorized into 2. They are A, superior and inferior courts, B, higher and lower courts, C, superior and lower courts, and D, supreme and lower courts. So the answer is superior and lower courts. The courts in Ghana can be classified into 2, which is superior and lower courts. So the superior courts include the High Court, the Court of Appeal, and the Supreme Court, whereas the lower courts include the District Court, the Circuit Court, and all that. Yes. So for number 4, the answer is C. Now let's go to number 5. It says, I came into effect in January 1993. I was drafted by a committee of experts and the Consultative Assembly deliberated upon me. I am the supreme law of Ghana and the fundamental law of the land. Who am I? A. The Bible. B. The common law. C. The 1992 Constitution. And D. Doctrines of equity. So this one is very self-explanatory. It's obviously the 1992 Constitution because it's the fundamental law of the country. It was also brought into effect in January 1993. So yes, that one is self-explanatory. So let's go to number 6. Number 6 says, which of the following statement is false? A. The National House of Chiefs is the final appellate court of the country. B. The Court of Appeal has no original jurisdiction. It is purely an appellate court. C. Appeals from the Court of Appeal lies to the Supreme Court. Then D. The Supreme Court is made up of the Chief Justice and other justices. So this one straight away it is A, because the National House of Chiefs is not the final appellate court of the country. The A says the National House of Chiefs is the final appellate court of the country. It's never the final. The final appellate court of the country is the Supreme Court. You get it? That's if you have a case, the last place you can take it, which means the final appellate is the Supreme Court. So that one straight away, the A is false. The rest are all true. The Court of Appeal has no original jurisdiction. It is purely an appellate court, meaning that if you have a case right now, let's say you want to sue someone or something, you can't send it to the Court of Appeal. You send your case to the Court of Appeal, assuming you sent it to another court, but you're not satisfied with the judgment they give, then that's when you send it to the Court of Appeal. So it's not like an actual court, it's more like an appellate court, yes. And the C says appeals from the Court of Appeal lies to the Supreme Court. That one is obviously true. Then D says the Supreme Court is made up of the Chief Justice and other justices, which is also true. So yes, so the correct answer is A. Okay, so now let's move on to number 7. Number 7 says Dash has exclusive jurisdiction for the enforcement of the fundamental human rights enshrined in the 1992 Constitution. Then we have A, the Supreme Court, B, the Court of Appeal, C, the High Court, D, the Circuit Court, and E, the District Court. So straight away is the High Court, because the High Court is the only court that deals with fundamental human rights cases or human rights cases, and you can see it in Article 33. So this one straight away, the answer is the High Court. The rest of them don't deal with human rights cases. You get it? Yes. So number 8. Number 8 says the following are types of legal systems except A, universal law, B, religious law, C, common law, and D, civil law. So the answer is universal law. Universal law is not a type of legal system. Religious law is a type of legal system which deals with, religious stuff, churches, and other things. Common law too is a type of legal system as well as civil law. So the answer is A, universal law. Now let's move on to number 9. Number 9 says goods that are identified and agreed upon by the parties before or at the time the contract of sale is made between the buyer and the seller are known as A, ascertained goods, B, unascertained goods, C, precious goods, D, specific goods, and E, future goods. So this one straight away, the answer is D, specific goods. Specific goods means that as of the time you are buying it, it is present. So if I go and meet maybe someone selling shoes and he say he's selling this shoe for 100 cedis, if I buy that moment, the shoe is a specific good. Because as of the time I'm making the contract or I'm signing any contract with him, the good is present. That's what the question is saying. Goods that are identified and agreed upon by the parties before or at the time of the contract. So if it's before or at the time, it is a specific good. Yes. Then let's look at the other options. So for ascertained goods, it means the goods are not identified that moment. Later on, that's when they are identified. But as of the time you are making the contract, they are not identified. Then the B is unascertained goods. So they are not identified at all. Later on, when they become identified, then they change from unascertained goods to ascertained goods. You get it? Then C, precious goods. There's nothing like that in contract law. Then the E is future goods. So for future goods, they are not in existence. You get it? Maybe if you are pre-ordering an iPhone or something, but then it's not in existence. So yes. So the correct answer is specific goods. Now let's move on to number 10. Number 10 says the subject matter of a contract of sale of goods must be A, money, B, goods, C, deliverables, then D, land. So straight away, the answer is goods. The subject matter of a contract means what the contract is actually about or what's the main topic. It's very self-explanatory. And you can't talk about sale of goods without the goods. Then if there are no goods, then it's not sale of goods. You get it? It's the goods that make it sale of goods. So straight away, the answer is goods, which is B. Now let's move on to number 11. Number 11 says, which of these is the last court in which anyone can make an appeal in Ghana? A, the Court of Appeal; B, the Supreme Court; C, the High Court; D, the Regional Tribunal. Straight away, the answer is the Supreme Court. The Supreme Court is the final court of the country, the final court of the nation. So yes, or the final appellate of the country as well. So the answer is the Supreme Court. Then 12. Which of these courts can hear appeals from the National House of Chiefs? A, the Court of Appeal; B, the High Court; C, the Regional Tribunal; D, the Supreme Court. Straight away, the answer is the Supreme Court. It's only the Supreme Court that can hear appeals from the National House of Chiefs. Now, the National House of Chiefs are like, they deal with disputes, land issues, and all that. So, assuming maybe you have a problem with your land, yeah, and the National House of Chiefs is not able to solve it to your satisfaction, it is only the Supreme Court that can do something about it. No other court can do it. The other one was the High Court, Court of Appeal. They can't do anything about it. It's only the Supreme Court that is superior over them. Yes. Yes, so the answer is the Supreme Court. Okay, let's move on to number 13. So number 13 says, when a case has been referred to ADR, ADR is Alternative Dispute Resolution. So when a case has been referred to ADR for mediation and the parties are unable to resolve it at mediation, it is referred back to the court by the mediator for trial to continue. Is this statement true? You have A, yes, this should be. No, it's not entirely true. C, yes, it might be true. D, no, it is not true. So yes, it's actually true. Assuming you invite a mediator to, solve your issue or something, he's not able to do it to your satisfaction. You have to send it to court. So the mediator will tell you to send it back to court. That's what the question is asking. And yes, it's actually true. So the correct answer is A, yes, it is true. Then number 14. To ensure success, parties in a negotiation must be willing and ready to compromise and settle without the involvement of a third party, and must act in good faith and be responsive to the legitimate interests, concerns, and fears of each other. Is this statement true or false? You have A, it is not true; B, it is not entirely true; C, it might be true; D, yes, it is true. So yes, it is true. So the answer is D. So it says that to ensure success, if you are negotiating with someone, so they give you conditions. It says first, you must be willing and ready to compromise and settle without the involvement of a third party, meaning that you should be ready to lose something. You get it? Assuming the mediator says, okay, this person has won the case, so that means he's taking the money, or you lose something at the end of the day. Once it will favor someone and it will not favor the other. So it seems that all of you should be ready for that. So that's the compromise part. It also says that they must act in good faith. Yes, acting in good faith means that you should be true about what you are saying. You should come in clean hands. And the other part says be responsive to the legitimate interests, concerns, and fear of each other. So it just means you should respect each other. That's all. So yes, it is actually true. So the answer is D. Yes, it is true. Let's go to number 15. So number 15 says arrange the following types of courts hierarchically from the highest to the lowest. And you have I, the Supreme Court; II, the Court of Appeal; III, the High Court; IVIN, the Circuit Court; and VIN, the District Court. So the question is saying you should rank it from the highest to the lowest. So the highest court of the country is the Supreme Court. So obviously the first one will be the Supreme Court. Then followed by the Supreme Court, the next highest or the second highest court in the country is the Court of Appeal. So the II will be the Court of Appeal, or the second highest will be the Court of Appeal. And the next one is the High Court. You get after the Court of Appeal, the next one is the High Court. So these are the three superior courts in Ghana. Then the rest, you have the Circuit Court and the District Court. So the Circuit Court comes higher than the District Court. The District Court is the lowest, like the lowest in the country, the lowest court. So straight away, if you are arranging it, I is going to be first, which is the Supreme Court. Then II, which is the Court of Appeal, is going to be second. Then III, which is the High Court, is going to be third. Then fourth, which is the Circuit Court, is going to be fourth. Then fifth, the District Court, is going to be the last. So that's how I'm going to arrange it. So VIN, and VIN. So yes, so the correct answer will be A. Then let's go to number 16. Number 16 says the correct sequence in the formation of a contract is offer, acceptance, agreement, and consideration. That's for A. Then B says agreement, consideration, offer, and acceptance. That's for B. Then C says offer, consideration, acceptance, and agreement. Then D says offer, acceptance, consideration, and agreement. So straight away the answer is D. Offer, acceptance, consideration, and agreement. Because the first thing is an offer, you making the proposal or making your intentions clear. Then acceptance, you agreeing fully to the terms of the contract. Then consideration is the value proposition in the contract or something of value. So if it's a car that is involved, the car is the consideration. If it's money that is involved, money is the consideration. That one is third. Then agreement is the last one. You fully agreeing to everything in the contract based on the value that is given. So if it's the car, you are okay with it, then that's the agreement. So the answer is D, offer, acceptance, consideration, and agreement. Now we move on to number 17. Number 17 says when counter offer is given, the original offer is A, then terminated, B, remains valid, C, is accepted and becomes a contract, then D, the original offer can also be accepted. This one is very self-explanatory. Once a counter offer is given, the original offer is terminated. A counter offer is you introducing something new to the contract that is not in the existing contract. So if someone says they are selling a house for 200,000 cedis, then you are like, oh, you only have 180,000 cedis. That's a counter offer. So the old one is cancelled, it's terminated. So the answer is A. Then number 18, an agreement becomes a contract if A, it is by free consent of the parties, B, parties are competent, C, it is enforceable by law, then D, none of the above. This one, the correct answer is supposed to be A, B, and C. But funny enough, they didn't state all of the above there because A, it is by free consent of the parties, meaning that they do it voluntarily. And of course, before an agreement becomes a contract, it has to be free from consent. It has to be by free consent. You don't have to force the person. You don't have to do it without their knowledge. So A is actually supposed to be correct. And B says parties are competent, meaning that they have to have legal capacity. And of course, before an agreement becomes a contract, it has to have legal capacity, which means that the parties are competent. So that one is also correct. Then C says it is enforceable by law. Of course, an agreement cannot become a contract if it's not enforceable by law. So it's actually all of them, but the most appropriate is it is enforceable by law. Once it's not enforceable by law, there are no negotiations. So if you have to choose an answer, it will be C. It is enforceable by law. Now we move on to number 19. Number 19 says an advertisement for sale of goods by auction amounts to, then A says an offer to hold such sale, B an implied offer, C an invitation to treat, then D a general offer. So the correct answer is an invitation to treat. Once you see an advertisement or an auction or anything, the correct answer is invitation to treat. Invitation to treat is like you inviting someone to make an offer. You get it? So if someone advertises something, the person is inviting you to enter into a contract with them. That's for you to buy it or something. So we call it an invitation to treat. Yes. So the correct answer is C. Now we move on to number 20. Acceptance by post takes place as against the proposer. A, when the letter of acceptance is posted by the acceptor. B, when the letter of acceptance is received by the proposer. C, when the offeree writes the letter of acceptance but doesn't post it. Then D, all of these. So the correct answer is A, when the letter of acceptance is posted by the acceptor. And this is based on the postal rules. The postal rules say that once you post a letter or once you reply with a post, the time that you reply, it means you've accepted it. So yes, so straight away the answer is A, when the letter of acceptance is posted by the acceptor. Now we move on to 21. 21 says, where Bright enters into a contract with Dinah, by which Bright bought a painting from Dinah, and both parties thought the painting was done by Leonardo da Vinci, when in fact it was painted by a local person. This is an example of A, unilateral mistake, B, mutual mistake, C, common mistake, then D, unfortunate mistake. So this one straight away the answer is mutual mistake because they both made a mistake by not knowing who actually painted it. So they both thought it was Leonardo da Vinci when it was actually a local person. So when both of them make a mistake about something, it's called a mutual mistake. So the answer is mutual mistake, yes, so B. Now 22, it says misrepresentation renders a contract A void, B voidable, C void or voidable, then D void and voidable. So the answer is B voidable. What this means is that if there's misrepresentation in a contract, it is voidable, meaning that it is left to the innocent party to decide whether the person wants to continue with the contract or not. It is not straight away void or it's not straight away cancelled. If the person wants to continue with it, then fine. But if the person wants to stop, then the person can stop. So we say it is voidable. So the answer is B. Then number 23. Blessing, who was selling a book to you, informed you that the book he is selling is able to sing a Christmas carol every time you open the book. The book is packaged and one can only detect whether it sings or not after opening it. Even though the other books Blessing has been selling did sing Christmas carols, it turned out that this particular one did not sing when you bought it and took it home. The contract can be set aside on the basis of A. Innocent misrepresentation, B. Negligent misrepresentation, C. Fraudulent misrepresentation, then D. Extraordinary misrepresentation. So straight away the answer is A. Innocent misrepresentation. This is because the question says that Blessing, who was selling a book to you, informed you that the book he is selling is able to sing a Christmas carol every time you open the book. And the question also says the book is packaged and one can only detect whether it sings after opening it. You get it? The question also proceeds to say that the other books that Blessing has been selling it is clear that they actually sing. But this one that you bought, it didn't sing. So this one, it's more likely that, Blessing didn't know about it. And the reason is that just because of the new information that the other ones actually sing. If the other books could not sing, we would have said it is fraudulent. Do you get it? This one, since they said it is clear that the other books could actually sing, we'll say it is innocent. Do you get it? And that's because the other books could sing. So the correct answer is innocent misrepresentation, yes. Now, moving on to number 24. A medical doctor who has diagnosed his patient of COVID-19 buys a 6-bedroom plush building located at Cantonment, Accra, worth 750,000 cedis for only 100,000 cedis. The patient agreed to the transaction because the doctor had indicated that, in view of the seriousness of his sickness, if the patient is not given close attention, he may lose his life. The contract can later be set aside on the basis of A. Duress, B. Undue influence, C. Negligent misrepresentation, and D. Serious mistake. So this one straight away, the answer is undue influence. Undue influence is a situation where someone uses his or her power or a position to influence you. The person doesn't force you, but then the person uses his or her position. So this one, the question says a medical doctor who has diagnosed his patient of COVID-19 buys a 6-bedroom plush building located at Cantonment, Accra, worth 750,000 cedis for only 100,000 cedis. So this one, the patient only accepted the offer because of what the doctor told him. The doctor said, looking at the seriousness of his sickness, if the patient is not giving close attention, he may lose his life. You get it? And obviously, the doctor is the one operating on him. You get it? So you obviously accept it because at the end of the day, the doctor can't do anything. So the doctor used his position to influence the innocent patient. So we say it is undue influence. He didn't force him, he didn't threaten him. But just the mere fact that he used his position to influence him is an example of undue influence. So yes. Now let's move on to number 25. Number 25 says, which of the following statements is not true about a contract which is liable to be discharged by frustration? And A says the frustrating event must have occurred before the contract was made. B says the frustrating event must have occurred after the contract was made. Then C says the frustrating event must make the contract impossible or improbable to perform. Then D says the frustrating event must be beyond the control of the parties. So this one straight away, the answer is A. The frustrating event must have occurred before the contract was made. So the frustrating event is like something that makes the contract vitiated or cancelled. You get it? So it can be an earthquake or something unfortunate that renders the contract vitiated. And it can't happen after, obviously. It has to be before. Because now you didn't have any idea about it. If it's after, I mean you had an idea about it. So at the end of the day, it can be frustrated, you get, because you had an idea. So it has to be before, you get it. So the answer is A. The frustrating event must have occurred before the contract was made. Let's move on to number 26. Number 26 says the agency relationship, which is inferred from the conduct of the parties, is known as an agency by. So we have A. Estoppel, B. Implication, C. Necessity, then D. Ratification. So straight away is implication. Yes. So implication is where someone is acting as an agent because of the person's conduct or behavior. So the person is actually supposed to do it. Do you get it? So that one is implication. The rest of them, for Estoppel, the person is not assigned to do it, but the principal's actions make it look as if the person is assigned to do it. Do you get it? So, oh, maybe the person does, the principal doesn't say anything about it. He's just watching. So we take it as if the person is actually supposed to do it. So that's Estoppel. For necessity, it's more like an emergency situation. Maybe someone forgets to turn off the fire when the person is cooking. So you see it and just turn it off because it's an emergency. The house could get burnt. So that one is necessity. Then ratification is where maybe the agent acts right now. The agent is not supposed to do it, but later on the principal is like, oh, no problem. I don't have a problem with it. You get it. So that one is ratification. Yeah, so that's for number 26. So for number 20, the answer is B, implication. So let's move on to number 27. Number 27 says the agency relationship which enables a person to act on behalf of another person in protecting the other person's interest against danger and harm is known as agency by. So we have A, estoppel, B, implication, C, necessity, then D, ratification. So this one is straight away necessity. Do you get it? So necessity is a situation where it's more like an emergency. So the person is more like saving you. You are not there, but because you are not there, something bad could happen. So the person is literally like saving you. So that one is agency of necessity. So the correct answer is C, necessity. So let's move on to number 28. So number 28 says the agency relationship which arises where an agent acts on behalf of the principal without the previous authorization of the principal, but after the act, the principal decides to adopt the act as his own, is known as agency by. So we have A, estoppel, B, implication, C, necessity, so then D, ratification. So like I said earlier on, the answer is ratification. So for ratification, you're not supposed to do it, but after you do it, the principal is like, oh sure, there's no problem, you could have done it, or he approves it. Yes, that's ratification. So should have the answer is D, ratification. Now move on to question 29. So question 29 says the following are types of goods under the Sale of Goods Act 1962 into brackets Act 137, except A, specific goods, B, new goods, C, unascertained goods, then D, future goods. So the answer is new goods. There's nothing like new goods. You get it? Specific goods, there's something like specific goods in contract law. We have unascertained goods, we have future goods, and nothing like new goods. So straight away, the answer is new goods, which is B. Now move on to the last question, which is number 30. Then for number 30, it says a contract of sale occurs when the seller agrees to transfer what to the buyer. We have A, power in goods, B, property in goods, into brackets, ownership of goods, then C, risk in goods, then D, money in goods. So straight away, the answer is B, property in goods or the ownership of goods. So a contract of sale occurs when you decide to transfer your property or the ownership of the good to another person. So when you transfer it to the other person, the person becomes the new owner. So that's straight away B, which is very self-explanatory. So property in goods. So yeah, so now we are done with the 30 questions. So if you are able to answer all these correctly, you are going to get 30 marks in the exams. You get it. Then the other parts, which is section B, is short answers. And this one is 10 questions, and every question is 3 marks. You get it. So you guys have to take this part very, very, very serious. And when you're answering, you have to know how to answer. So I'm going to show you guys how to answer questions like this.